Hello, my name is Michael Tessera and I prepared this presentation titled ACCC Cheat Sheet, October 2023. And I guess if you've been watching my YouTube station or channel, you will see that I've been doing these cheat sheets for the last few weeks and trying to cover the period from July up until the current date. So with this particular cheat sheet, I'll be totally up to date. And the idea is I'll summarise all the ACCC developments which occurred in that relevant month. So in this presentation, everything that occurred in October. And this will save people a lot of time in being able to just listen to this presentation rather than having to read all the press releases that put out by the ACCC. And I very much like that gift that I found of a very young Ryan Reynolds doing a very bad job of trying to cheat discreetly. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice as Sarah Legal Consulting for the last 15 or so years, and I help companies, individuals with competition and consumer law matters. I also do some expert consultancy work for various legal publishers on competition and consumer law. Prior to that, I worked at the ACCC for about 15 years in a variety of roles, Director of Enforcement and also the Director in charge of the Sydney Mergers and Asset Sales branch. Now, the outline's pretty similar to the previous cheat sheets: courts, enforcement action, mergers, inquiries and consultations, speeches and other. Two new categories this month: product safety and warnings. Now, there was only one case that came down in October and it involved ACCC and Meta platforms. And it's an interesting case. Its background is actually the Andrew Forrest case that was commenced in early 2022, where he launched criminal proceedings against Meta, alleging the company had failed to remove his name and image from various advertisements on Facebook promoting various false cryptocurrency products that were on the market. And he commenced these criminal proceedings under Part 10 of the Commonwealth Criminal Code, but he could only continue the proceedings if he had the consent of the Commonwealth Attorney General, which he actually got. So he has been approved by the Commonwealth Attorney General to continue running this criminal prosecution as a private citizen. Then in May 2022, the ACCC commenced its own legal action in the federal court. These are civil proceedings against Meta, alleging largely the same things: that the company had engaged in false, misleading or deceptive conduct in relation to various cryptocurrency scam advertisements. The main difference was that in addition to Andrew Forrest, they alleged that there were other representations made involving other prominent Australian public figures. So it was a broader case, but there was overlap with the Andrew Forrest case. And in this particular matter, this particular case involved Meta applying for interlocutory orders to stay the ACCC proceedings pending the determination or disposal of the criminal proceedings in WA. Now, the judge dismissed Meta's application. He concluded that it was premature to be seeking a stay and that Meta hadn't appreciated the protective mechanisms which were available to the court to manage any possible prejudice that could arise from the two sets of proceedings continuing simultaneously. He also didn't believe that the interests of justice required an immediate stay. He also commented that active case management techniques could be applied to ameliorate any risks identified by Meta. So on balance, he believed it was in the interest of justice to maintain the two proceedings at this stage. The interesting thing about the judgment, it's relatively short, and that's because a large chunk of the decision has been withheld from publication. I'm not too sure whether that's confidentiality or whether the submissions being made about the publication of the judgment might lead to prejudice. So only 20 of the 120 odd paragraphs have been published at this time, and I'm not too sure whether the rest is going to be published or maybe held back till later on. Now, the first enforcement action involved Tesla, and this was an alleged breach of the new mandatory standard of button batteries. And what was claimed by the ACCC was that Tesla had put a number of fobs and illuminated door sills into the market which had button batteries without having tested them first. So they had to withdraw all these fobs and illuminated door sills from the market and have them tested. And then once they passed the relevant test, they could be put back on the market. So as you can see, the Model 3 and Model X have been tested and back in the market, and the others will be probably back on the market once they've been tested. But it just shows how it's important to ensure you comply with the standard, have products tested before making them available. And here Tesla was fined $155,000 through an infringement notice. The second case was Brilliant Lighting, and this was another RPM case. Seemed to be a spate of these in the last few months. And in this case, Brilliant Lighting actually admitted to having engaged in missile price maintenance. They wrote letters to various retailers and distributors and attached a price list and effectively told their retailers and distributors they had to sell at those prices or couldn't discount the product. So this case was resolved through an ACCC undertaking. So it's another case where the ACCC has chosen to resolve an RPM matter without going to court. The next one involves alleged breaches of the Horticulture Code. So another very active area for the ACCC in terms of their enforcement. Here, Neutrano was issued with an infringement notice, $24,000. And this case actually arose from complaints from various growers. So a number of the other cases have arisen from audits of compliance, but here they actually received a number of complaints. And there were 3 alleged breaches, 2 of the Horticulture Code. The first was that Neutrano failed to specify the price it received for produce in grower statements, so that's a requirement of the code. And the second related to its HPAs, or horticulture produce agreements, that did not adequately specify the quality requirements and specifications that would be used to determine the quality of the grower's produce. So 2 pretty clear breaches of the code. The third alleged breach was actually belief by the ACCC that some of the terms in their standard contracts were actually unfair, and an example of one there was Neutrano had this absolute discretion to change the product specifications. So that was an important case in terms of the scrutiny which the ACCC is putting on the Horticulture Code. Again, it was resolved with a Section 87B undertaking. The further enforcement outcome involved Jeep, which the company that imports and distributes Jeep vehicles in Australia is called Stellantis. And effectively there'd been concerns to the ACCC over the way Jeep was handling complaints, particularly consumer guarantee complaints, and they wouldn't be the only car importer distributor with many complaints to the ACCC about consumer guarantees. But I guess the encouraging part was that Jeep agreed that there were problems with the way it was explaining consumer guarantees to consumers, the way it was assessing whether people were entitled to a refund. There were lengthy delays, multiple repairs, delays in parts being available, and Jeep acknowledged that its staff may not have properly understood the way consumer law guarantees worked, and furthermore they acknowledged some deficiencies in their internal policies. They signed an 87B undertaking to agree to a number of measures, including reviewing the way they handle customer complaints, making relevant changes to training, to their internal documents, ensuring that all their salespeople and complaints handling people understand the way consumer guarantees work, writing to all new Jeep customers to tell them of their consumer guarantee rights. So that's a very positive step by Jeep, and it'd be good if some of the other car companies could take a less combative approach over this issue and do what Jeep's done. Now, the first merger, I mentioned the Helios Australian Clinical Labs merger in a couple of cheat sheets ago, but effectively the ACCC expressed serious concerns about the merger in a number of areas, and this is the response by the merger parties to offer a range of divestitures. And they're hopeful if they offer these divestitures, they might be able to get the merger approved. And they've actually proposed to divest a lot of different little operations around the country, 60 ACCs in Perth, 25 in Victoria and 14 in Northern Territory. And when you look at the percentages, it's quite high, 16% of the business effectively in Western Australia, 2% in Victoria, and their entire business in the Northern Territory. So that's a significant divestiture, but I don't think it's going to address all the concerns. The ACCC was concerned about public tenders in Victoria to hospitals, also about some other areas of the market such as veterinary products. So this divestiture doesn't seem to me to tick the boxes that would need to be ticked to get this merger across the line. The very big merger that came out in October was a Brookfield Origin merger, and everybody had been really awaiting this decision, and it is a very, very significant decision. The ACCC had been faced with an authorisation application by Brookfield to purchase Origin Energy, but there are actually 2 transactions. The first was a consortium led by the Brookfield Global Transition Fund, which was seeking to buy Origin's energy markets business, which was effectively it's an electricity generation and electricity and gas retail businesses. And then another company, MidOcean, was going to buy Origin's upstream gas interests. So what the ACCC had to do was consider two tests on the legislation. The first was whether the merger was going to substantially lessen competition, and in the alternative, whether the public benefits outweighed the public detriments. Now, looking at the first test, the ACCC concluded that it didn't pass that test. Their view was that the merger would substantially lessen competition in the market, and they set out quite a number of reasons, and they're all sort of related. The first is they were concerned about the vertical integration that the merger would create in the market. See, Brookfield currently controls a company called AusNet, which owns significant energy network infrastructure in Victoria, and then you've got Origin's energy retailing generation business, so there's an overlap there. And the ACCC said that they had a long-standing competition concerns with combining monopoly energy network assets with businesses that use those assets. So this is being represented at two stages in a functional market. So as I said, the last point there, the controller of a monopoly network which owns downstream or upstream market interests has the ability and incentive to discriminate against its rivals. So if you're an upstream provider, there's a strong temptation and the ability to discriminate against your downstream competitors by self-preferencing, refusing supply. So that were the major concerns, and they added some further concerns. The strongest competition concerns related to the common control over AusNet's Victorian high voltage electricity transmission system. So that was the area of most concern. They were particularly concerned about Brookfield's ability to influence AusNet to obstruct rival generators from connecting to transmission grid. So this is this idea of stopping companies from gaining access to the network. And then even if Brookfield was unable to engage in very obvious or extreme vertical foreclosure, they could, there was a strong potential that they would be able to discriminate in subtle and other ways that were difficult to detect. So these were genuine and serious competition concerns. However, the merger did get through on the net public benefit test, and this is a really significant aspect of the ACCC's decision. They believe that the public benefits, which primarily related to renewable energy and reducing the emissions from fossil fuels, were so significant they outweighed any public detriments. So as you can see, they acknowledge that the public benefits and public detriments were finally balanced, and they considered that not only were the public benefits very strong, but there was also some comfort from these undertakings which Brookfield, AusNet and MidOcean had offered the ACCC as part of the transaction. So they concluded that the acquisition was likely to result in an accelerated rollout of renewable energy generation. So that was the big sort of factor that led to the approval. Brookfield Transition Fund has a specific focus on transitioning to renewable energy, and also, I guess, Brookfield's decision to buy Origin, which is one of the largest emitters of greenhouse gases in Australia, and then changing its whole approach to greenhouse gas reductions was a very important consideration. As you can see, Brookfield would be driven by a strong imperative and commercial incentive to lower emissions quickly. The inference being that Origin may not have had the same imperative or commercial incentives. They also noted that accelerated build-out of Origin's renewable energy generation would be a material benefit to the Australian public. Reduction of greenhouse gas emissions would be a significant public benefit, so that's all obvious. The interesting thing, they're a bit sceptical as to the claimed public benefits arising from the acquisition, which Brookfield had put it between 20 billion to 30 billion, but even though it may not be that large, it was still significant. They're also of the view that the proposed acquisition was likely to increase the speed of renewable energy generation rollout in Australia. With such a big investment being made, clearly it was going to provide a lot of impetus to renewable energy generation. And they noted Brookfield's reputation, its commitment to progress the rollout, and that is also going to be subject to both public scrutiny and reporting obligations to the ACCC. So even though the commitments haven't been sort of um, committed to in an undertaking, the ACCC is going to be watching quite closely through these various undertakings, and obviously the public scrutiny is not an unimportant factor nowadays, particularly from various stakeholders. So this is a very significant merger, and it's been watched across the world as being probably the first time an antitrust regulator has put so much weight on, I guess, environmental benefits to clear a merger which was otherwise anti-competitive. The other merger that was looked at was Petstock, and this is a bit of a strange one because Woolworths wanted to buy Petstock, and when the ACCC started investigating it, they discovered that Petstock had been acquiring businesses for the last few years without telling the ACCC, and the inference being that maybe Petstock has acquired a significant degree of market power in the industry. So, as part of the approval process, both Woolworths and Petstock have offered some divestitures, and you can see the businesses they bought: Best Friends Pets, Pet City, Animal Tucker Box, and Pet Aquarium, Warehouse, and online businesses as well. So Petstock and Woolworths have offered court enforceable undertakings to sell quite a large number of businesses. As you can see, 41 specialty pet stores, 25 co-located veterinary hospitals, 4 brands and 2 online retail stores. So Petstock has been very acquisitive for a number of years, and I don't know whether this will get over the line. Probably will get over the line. The key thing here is that the directors and Petstock, the company, could still be liable for penalties for having breached Section 50 by acquiring all these assets without obtaining ACCC approval. So there could be some further enforcement action down the road, even if the merger is signed off by the ACCC. Then moving to product safety, there was sort of a warning put out about lithium batteries, and as I said in previous cheat sheets, the ACCC is very conscious to provide warnings to consumers about particular issues. So here they're letting consumers know about the serious fire hazards, particularly if you don't dispose of these lithium batteries properly. As they note, they can overheat or explode if they're used, charged, or disposed of incorrectly. And they also note that when you're using these batteries, you have to make sure they're not exposed to heat or moisture or crushed. So you've got to keep them out of traditional waste facilities. You really need to store them up and then take them to various recycling organisations. And as you can see at the bottom there's been reportedly 1 death from a lithium ion battery fire, and there have been 231 product safety reports relating to various battery fires and other problems over the last few years. So it's a very serious issue. The other product safety one is also one that's been in the news a little bit. LG Batteries found a fault with some of its batteries and effectively has issued a recall. However, it seems also that a number of consumers has been continuing to use the batteries, even though there's a very significant risk associated with them. So LG issued some media releases advising customers to immediately switch off their recalled LG batteries, and the ACCC's come in and reinforced that view and said that really there's a serious risk of injury or death, so you just have to stop using these batteries immediately. And the different brands are all made by LG, but the brands are LG, Solax, Opal, Red Earth, Iguana and Vata. Then the second interim report from the childcare inquiry came out on the 1st of October, and the ACCC had done quite a lot more work since the first report, and it noted some things I guess were maybe pretty obvious. Market forces have failed to meet community expectations and government objectives in terms of providing adequate childcare. Supply of childcare services in advantaged areas is higher than in remote communities and lower socioeconomic areas, which again is probably not a surprise. They noted there was a need for additional and targeted support for First Nations and underserved communities. An interesting policy observation is that the activity test which applies in this area is problematic, that the current activity test means that those in low incomes who seek to increase the hours of work can actually be disadvantaged as a result. They could face a higher proportion of out-of-pocket expenses for childcare. So that's suggesting to the government they need to get the policy settings changed a bit to be more equitable. They also noted the cost of providing healthcare is increasing, the sector's profitable, educators are the most important aspect of the quality, availability and profitability of childcare. They also noted overseas developments which seem to be going a different direction. In the OECD, countries are looking at supply side subsidies, increased regulation. It's a highly regulated sector already, so it staggers you to think how they could regulate it any more. And they've sought comments on this particular interim report by the 29th of October. There's also this funny report about mobile towers. I didn't realise they actually did this report, but they look at regional mobile infrastructure, and they found that all the three telecommunications companies have sold their mobile tower networks to independent companies. But then they conclude that the regulatory regime for tower access is no longer fit for purpose. And what they say there is having tower companies independent for mobile networks should result in significant incentives from these companies to seek to co-locate different telecommunications providers using the same tower. So in other words, one tower could be used to provide services to Telstra, Optus, TPG, but that doesn't seem to be happening. So the market's not behaving in a way that seems competitive. And as they note, the telecommunications companies still drive communications investment decisions in various areas. And it seems that these third-party tower operators will only really build a tower when they have a commitment from a particular network to use them. And the question there is whether there's some obstacles to third-party mobile tower operators from running different networks through the same tower. Maybe there's contractual limitations on their ability to do that. Clearly there's a reference here to remaining vertical integration between Telstra and the company which it sold its towers to, Amplitel, suggested that it is not easy for them to provide services to other competing telecommunications companies. And the interesting observation here, particularly in the context of the Optus outage the other day, which I'm doing this obviously in November, of using roaming where a particular system goes down due to a natural disaster. And this is the curious thing about the Optus response to their own outages. They didn't make roaming available to other customers at that time. So I guess there's been a lot of questions asked of Optus about that. There was also this very strong warning issued to the caravan industry, and the caravan industry has been under the pump for a few years now. They've been included in the enforcement priorities for the ACCC for a few years, and now there's very direct warning that's identifying particular problems and saying in very clear language that strong enforcement action will be taken against retailers. And they've got a couple of examples here. Firstly, there was an example of a retailer telling a customer that the price of the caravan was fixed and then tried to increase the price. And then there was also allegedly false representations about the caravan weight, which obviously raises some big safety issues if you think the caravan weighs a different amount to what it actually weighs. And it's clear here the ACCC is going to be looking at some enforcement action in the near future against various caravan operators. So watch out if I was a caravan operator. There was also speech, and it was in regulatory priorities and challenges posed by the digital economy. And this was delivered by the chair of the ACCC, Gina Cass-Gottlieb. And she goes through various things that have been happening, particularly in the proposed legislation front. Obviously, they have recommended a number of changes to the way the digital platforms are regulated in Australia. So they believe that it's important to introduce these changes because digital platforms markets feature unique combination of characteristics which make them prone to competition issues, and that's obvious. There's been a lot of competition issues all around the world involving digital platforms. Some large digital platforms have significant market power and act as gatekeepers, and that's also obvious. There's been many examples around the world of them using their significant market power and being taken to court regularly. And throughout our digital platforms work, they've established a strong evidence base of competition and consumer harm. So their reports have been quite exceptional in terms of identifying the particular problems which digital platforms pose, both on a competition and a consumer front. She also goes through and looks at various other things that have been proposed to government. The first is unfair trading practices provision, which has resulted in a Treasury consultation which is going on at the moment. Also, they've proposed specific mandatory laws in relation to digital platforms. This is addressing through codes of conduct and looking at all wide range of issues: scams, harmful apps, fake reviews, notice and action requirements, stronger verification for business. And the government set up this competition review task force, which is looking at all these ACCC proposals at the moment, is having some roundtable discussions with various people. They also looked at international developments. Obviously, the big issue recently has been the European Community decision to designate a large number of digital platforms under their Digital Markets Act. And also the ACCC has been looking at artificial intelligence issues and what competition issues they may raise, particularly in relation to these algorithms that might be operated by artificial intelligence, which might facilitate price fixing. And clearly she has reiterated the importance of merger changes to advance this idea of precautionary principle, which she spoke at in a speech she made last month. But effectively, the view has to change from, I guess, erring on the side of caution when it comes to mergers. So stopping mergers that potentially could lessen competition, rather than maybe letting through a merger on efficiency grounds that could end up lessening competition significantly in the market. The other one was the Australian Energy Market Operator, and this was an application which I mentioned a couple of months ago, where it sought authorisation to get together with electricity industry participants to coordinate scheduling of repairs, maintenance, renewals, upgrades, etc. And interim authorisation was granted, so they were allowed to start talking. But after the ACCC went to the market and looked at it, they decided to deny the authorisation. That's because they didn't think the coordination would result in any public benefits. Rather, the public detriments would outweigh the public benefits, and therefore it wasn't approved, which is somewhat embarrassing for the Australian Energy Market Operator. And I guess one factor that influenced ACCC on whether to say no to this particular authorisation was these proposed reforms that have been spoken about that are going to be brought in relation by the Australian Energy Market Commission. They might address a lot of the things that the authorisation wanted to deal with. So probably a bit of a wait and see how that pans out. The final other was the NBN Special Access Undertaking, which has been going on for a couple of years now. NBN keeps proposing SAU to the ACCC and keeps getting rejected. Finally, it's been accepted on the 17th of October. And it's important, the SAU, because it actually sets out how broadband providers will be able to access NBN over coming decades all the way to 2040. So it's an important document, you've got to get it right. And what the SAU does, it introduces these long-term pricing commitments that will restrict annual increases in NBN average wholesale prices to CPI. So that's a very significant, element of the SAU. Also, a new pricing structure, a new basic voice and data service will be offered at about half the price of the existing broadband offer, which is very good. The next one's a bit strange because the wholesale prices for 25 and 100 megabytes per second or faster speed service will be reduced, but that'll be offset by a small increase in the wholesale price for 50 megabytes per second. So probably the two least popular plans are going down in price, and the most popular plan is going up. So I don't know that's a great outcome necessarily. And then finally, volume-based capacity charges will also progressively reduced before being completely withdrawn in 2026. So there's a lot of good aspects of this SAU, and ACCC believes it's not just about reducing prices. What's probably more important is reducing barriers to entry to retailers coming into the market and providing vigorous competition to the incumbents. So the ACCC ACCC believes SAU will achieve that outcome. So that's all I had in this particular thing. I guess the main observations from October were that Meta continues to try and stop the ACCC case against it from proceeding, pointing to this criminal prosecution commenced by Andrew Forrest in WA. And I think at some stage the ACCC case will have to be stayed, probably when the other case comes to the business end. But really, I think Meta's got to stop trying to stay. It's not going to be successful. And I think the other interesting aspect is whether the remainder of this judgment is going to be published. I'm not too sure its status at the moment, whether it's being looked at for confidentiality or whether it's simply not going to be released until later on, until maybe the criminal proceedings have been finalised. The ACCC has continued its very active enforcement in relation to the Horticulture Code and Bud and Battery. So if you're in those sectors, be aware that the ACCC is very vigilant. It's very good to see RPMs, resale price maintenance, being resolved through 87B undertakings and without court action. I think the cases in recent months have suggested that most of the companies engaged in the conduct didn't realise it was illegal. No point taking a company to court when they don't know they're breaking the law, in my view. The Brookfield Origin Energy approval is a very significant decision, not just in Australia but globally. It's been looked at by overseas jurisdictions, and I think it gives a really clear guide to companies who are wanting to put mergers to the ACCC that if they can promote environmentally beneficial outcomes arising from their merger, they're going to be given significant weight as a significant public benefit, and maybe it'll be the difference between getting the merger over the line or not. So I think everybody will be looking clearly at what they can do in that particular space going forward. The caravan manufacturers better watch out. They've been a strong focus of the ACCC for a long time now, and it's the clearest warning I've ever heard that there's going to be some litigation around the corner. So I think they need to get their house in order. And then finally, it's good to see the NBN SAU finally getting over the line. There's been a lot of work. I applaud the ACCC for being very strict in what it accepted, and I think what it ultimately accepted was very positive in many respects, except probably for the fact that the two least popular plans will be going down in price and the most popular plan will be going up, at least at the wholesale level. But I guess if there's sufficient retail competition, then we might see benefits across the board. So that's all I had in this particular month. It's been another busy month for the ACCC. I guess the main one that really sticks out was Brookfield Origin. That's a really significant decision, and I think we're going to be seeing more environmental claims being put forward in merger authorisations going forward. So that's all I had. If you have any questions, feel free to give me a call or drop me an email. Bye-bye.